screen. We break it down, clear and clean. Landmark cases, news that's true. Legal concepts explained for you. Legal insights, know your right. Truth and justice in plain sight. From tech to ethics, case by case. Join the stream, stay in the race.
Welcome to Legal Insights, your weekly dive into the cases that shape the law and the lives behind them. I'm your host, Akoto, and this is the case of the week. Today we are traveling back to 1961 Ghana, a nation fresh from independence, to unpack a landmark case, Akoto and 7 others. It's a story of detention, defiance, and a legal battle that tested the heart of a new democracy. Picture this: 8 ordinary citizens, from storekeepers to linguists, caught in a political storm, fighting for their freedom. Ready for a legal soap opera with high stakes? Let's dive in. It's November 1959 in Ghana, just 2 years after independence from British colonial rule. The air is electric with hope, but also tension. President Kwame Nkrumah's government is navigating a new nation, but whispers of dissent are growing, especially in the Ashanti and Brong Ahafo regions. Enter Osei Akoto, a senior linguist to the Asantehene, the revered Asante king, and 7 others: a lorry driver, a storekeeper, a subdivisional chief, and more. These aren't high-flying elites. They are everyday Ghanaians, from house number 0.141 in Kumasi to a transport owner in Swami. But on November 10, 1959, their lives changed forever. Under the Preventive Detention Act of 1958, the Governor General, acting on Kwame Nkrumah's authority, signed an order, Preventive Detention Order Number 5. The accusation: these 8 individuals were allegedly advocating a violence in a manner prejudicial to the security of the state. No trial, no evidence presented in court, just a sweeping executive order, and they are detained. Imagine the shock. One day you are running a store, the next you are behind bars. No questions asked. The act allowed detention without trial for up to 5 years if the government deemed you a threat. Harsh, right? The 8, led by Bafo Osei Akoto, aren't going down without a fight. They turned to Dr. J.B. Dankwa, a legal giant and one of Ghana's founding fathers, to represent them. Their weapon: a writ of habeas corpus, the ancient legal remedy demanding the government justify their detention. They take their case to the High Court, arguing 3 big points. First, they claim the Minister of Interior, who signed the order for the Governor General, acted with malice. Second, they argued their alleged actions don't fall under prejudicial to state security. And third, they invoke the Habeas Corpus Act of 1816, saying the court must investigate the truth of the government's claims. The High Court, however, isn't buying it. They refuse the writ, saying the detention order is lawful on its face. Undeterred, Akoto and the others appealed to the Supreme Court of Ghana before Justice Kosa, Van Laar, and Akiwumi. The stakes are high. This isn't just about 8 people. It's about the power of new government to lock up citizens without trial. The courtroom is tense, with Dr. Dankwa facing off against Attorney General Geoffrey Bing, a British lawyer defending the state's iron grip. Let's break down the legal meat of this case. The Preventive Detention Act was a beast. It gave the executive near unchecked power to detain anyone deemed a threat. No questions asked. Akoto's team argued this violated the rule of law and separation of powers. They leaned on the English case like Liversidge versus Anderson, where courts limited their scrutiny of executive detention orders during wartime. But Ghana wasn't at wartime. This was a peacetime. Dr. Dankwa pushed for judicial review, arguing the court should probe the minister's good faith and the truth of the allegations. The Supreme Court, though, takes a hard line. On August 28, 1961, they deliver a unanimous ruling. The detention is lawful. Why? They say the preventive detention order is valid on its face, signed by the minister and names of the appellants correctly. Following Liversidge, they rule that the court can't question the executive satisfaction that the detention was necessary unless there is clear evidence of bad faith, which Akoto's team couldn't prove. The burden, the court says, is on the detainees to show malice, not the government to justify itself. Ouch. That's a tough blow for judicial oversight. The court tackles the Habeas Corpus Act of 1816, which Akoto's team argues required deeper scrutiny. The justices agree it applies in Ghana as a statute of general application, but they interpret it narrowly. They say the court's job is to check the order's legality, not to play detective on the government's reasons. The appellant's hopes are dashed, and they remain detained, some for years, in grueling conditions. This wasn't just a legal loss. It was a personal tragedy for those ordinary citizens who sacrificed years of their lives. So, why does Re Akoto matter? It's a stark lesson in the fragility of constitutional protections. The case exposed how the Preventive Detention Act tipped the balance of power towards the executive, sidelining the judiciary and legislature. It's a cautionary tale about unchecked authority, especially in young democracies. Ghana's Supreme Court essentially said, trust the executive. But at what cost? The case is still taught in Ghanaian law schools, and the annual Re Akoto Memorial Lectures, started by the Ghana School of Law, honor the sacrifices of these eight and their fight for justice. Bafo Osei Akoto and the 7 others weren't just names in a law report. They were a linguist, a driver, a storekeeper, people like you and me, caught in a political crossfire. Their story reminds us that law isn't just about statutes and courts. It's about lives, families, and the fight for fairness. Thank you for listening to this episode. Subscribe for more. Follow us on all our social media handles. And see you next week. Until then, be safe. Bye.
From the courtroom to your screen, we break it down clear and clean. Landmark cases, news that's true, legal concepts explained for you.